Okay, welcome to this presentation on the legislative process. It's AC 1.1 of Unit 4 of Criminology Level 3. Now, when we're talking about the legislative process, what we're basically talking about is how laws come to be made in this country. There's always questions on this in the paper, and also in this PowerPoint I'm going to have a look at the role of the judge, and in particular their role in creating laws. But what I'll do is when we get to those key bits in the presentation where there are common questions that come up year after year, I'll alert you to that, and you can make sure that you really know your stuff so you're okay for when you're answering those questions. But as an introduction, because what I find is that a lot of students don't really understand how government works, we're going to have a little look at the government of this country and how it's made up, because ultimately it's the government that makes the laws. So, you may or may not be aware that there are actually two houses of Parliament. We've got the House of Commons. You can always tell it's the House of Commons because it has green seats. And the House of Commons is made up of 650 members who are called Members of Parliament, MPs, and they represent a constituency which elects them at a general election. And in this country, general elections are held every 5 years minimum. They can be held a little bit earlier than those 5 years, but 5 years is the maximum term for a government in this country before a general election is called. And the House of Commons is made up of the people that are in power, excuse me, the people that are in power, such as the Prime Minister, who then appoints a cabinet, and the cabinet are those people who have the top jobs within Parliament, such as Chancellor of the Exchequer, Foreign Secretary, Education Secretary, Health Secretary, Home Secretary, etc. There are many, many more. Now, I was going to put a few names up, but actually I'm recording this on the day that Boris Johnson has flown up to Balmoral to resign, and Liz Truss has just come in, so I don't know what her cabinet is. So otherwise I'll give you some names, but take it from me, the cabinet are the top jobs. And of course you've then got the opposition, which are all the parties that didn't get the majority in the general election. So the question you could ask is, what is the difference between Parliament and government? And the answer to that is that Parliament is all those 650 MPs, and those could be Scottish nationalists, Lib Dems, Conservative, Plaid Cymru, Welsh nationalists, there could be Ulster Unionists, Northern Ireland, etc. That's Parliament, it's all those MPs, but government are the party in power. So at the time of recording this, that's the Conservative Party with the new Prime Minister, Liz Truss. That's who govern, who are responsible for running the country. So what's the role of the House of Commons? Well, we know they're directly elected, but what they're supposed to do is they're supposed to make policy, which then decides how the country is run. They debate matters of current concern. At the time of recording this, it's the cost of living crisis, energy, war in Ukraine, and etc. They will then debate, they'll look really carefully at things, scrutinise them, and vote on whether to approve the laws that the government has proposed. And that's where we're coming at it from in this presentation for your Criminology Level 3 qualification. And the other role is for MPs to challenge the government, to hold it to account, to rigorously question it, to make sure that they are doing what is right for this country. So the leader of the opposition, Keir Starmer, if he doesn't agree with something, will challenge the government, make sure they are held to account and don't do anything that would go against the interests of the country. And of course, your MP is elected, so they are also there to represent the views of the electorate. So one could argue that given the fact that the majority of the country voted for Brexit, that's the views of the electorate. So Boris Johnson then was elected as Prime Minister with a mandate to bring Brexit through because that's what the electorate wanted. So that's what I mean by the views of the electorate, because the other thing to remember is if an election is held every 5 years and your local MP doesn't do or doesn't look after your views, then you have the right to vote against them in the next election. If lots of people don't agree, the MP doesn't keep his job or her job. The second house, which you may not know so much about, is the House of Lords, and that's the red seats. So there are two chambers in the Palace of Westminster, in the Houses of Parliament. Notice it's the Houses of Parliament, the Commons, and you've got the Lords. Now, the House of Lords is made up of 700 members. They are unelected, they're unpaid, and attendance is voluntary, whereas MPs obviously paid. And it's made up of hereditary peers. Now, hereditary peers are people like this guy, Thomas Edward Coke, the 8th Earl of Leicester. And basically, he is on the House of Lords purely because he was born into the aristocracy. So he is Viscount Coke, and he sits on the House of Lords. Now, these hereditary peers are gradually being phased out, because lots of people think, well, why, just because you're born into the nobility should you have a right to sit in the House of Lords? So they're gradually being phased out, and they are being replaced with what are called our life peers. So people who hold a place in the House of Lords for the duration of their life until they die. And they are appointed usually by a Prime Minister for contribution to society or politics. So here's an example of some of the people that are life peers in the House of Lords, some of the 700. So this guy here, Michael Grade, who you may know, he's known as Baron Grade of Yarmouth, but he used to be the controller of the BBC and the chief executive of Channel 4. So his background is in the media and in TV, quite a famous man in terms of television. So he has been elevated to the Lords for his contribution to society in the televisual arts. There's this lady here, I remember her from my youth. This is Dame Floella Benjamin, or Baroness Benjamin of Beckenham. She's an actress, singer, presenter, businesswoman, and she used to present many years ago Play School, which is a programme for very small people indeed, and a programme called Play Away. So she was a children's TV presenter. She is now in the House of Lords. You've also got this guy, Sir Ian Botham, Baron Botham, who was an English cricket commentator, ex-captain of the England cricket team, used to commentate in cricket for Sky Sports, very famous cricketer. He is in the House of Lords. So you have these people, from sport, from television, from the arts, who are appointed to the House of Lords, but at the same time, lots of people who are ex-politicians, when they've either lost their seat or they retire from politics, are elevated to the House of Lords. So this guy here, Joseph Edmund Johnson, known as Baron Johnson of Marylebone, you might think, he looks vaguely familiar, that face is familiar. That is the younger brother of Boris Johnson, who resigned from Parliament over Brexit. He didn't agree with his brother about Brexit, but he did stand for re-election, but his brother very nicely made him a Lord, so he has a place in the House of Lords. So some people feel that this constant moving of old politicians up into the Lords doesn't help matters. You make your own decisions over that. And coupled with these hereditary peers and life peers, we've also got 26 bishops of the Church of England. So people like this guy, Justin Welby, the Archbishop of Canterbury. He is one of the 26 bishops who also sit in the House of Lords. And there's been a campaign recently led by the militant atheists to say, well, why should bishops be allowed in the House of Lords? Why should someone of a specific religious faith have any say in how our country is governed? Specifically because they will be influenced by their faith, and that may not be right. Again, you make your own decisions about that. So that's the House of Lords. And finally, what is its role? Well, it's there to complement the House of Commons. It can scrutinise and it can amend proposed laws, proposed legislation. That was one of the reasons why Theresa May had so much problem getting Brexit through, because the Lords kept not letting it through. They can question government, they can debate policies, issues and matters of general concern, and they can also introduce bills, laws. So any of those 700 people in the House of Lords can bring in laws. They can also, as I've mentioned before with Brexit, delay legislation to allow further time to research and consult on acts, bills, laws that are going through Parliament. And lastly, we have the Crown, the Queen. So here she is at the state opening of Parliament, back in the time when Prince Philip was still alive, and Parliament is always opened in the House of Lords, and the House of Commons is summoned to hear the Queen's speech that is delivered to the Lords, who are all dressed in their finest robes, ermine, wigs, etc. And what does the Queen do, or what does the role of the Crown do? Well, as I've just mentioned in that photograph, they open each parliamentary session with a traditional ceremony. They give royal assent to all legislation, so a law does not become a law until the Queen has signed it as law, and they appoint and dismiss the Prime Minister. Now, I mentioned that as I'm recording this, Boris Johnson has finally gone and Liz Truss has taken over, and actually in the news today, as I speak, Liz Truss has just flown up to, Boris Johnson has taken a private jet up to Balmoral to meet the Queen, where he is going to resign as Prime Minister, and an hour afterwards, Liz Truss has taken another private jet and has gone up to Balmoral to meet the Queen, where she will be appointed the new Prime Minister. So that is the role of the Queen, so to sign off the laws and to appoint and accept the resignation of the country's Prime Minister. So here you see a picture of an act, a law. This is the Australia Act of 1986, and I can tell it's now a law because there is the Queen's signature. Elizabeth R stands for Elizabeth Regina, the Latin for Queen. And I know that's now a law because it has got the royal seal of approval. So that's how it works. So let's look at this in a little bit more detail. So as laws go through Parliament, or how does something become a law? Well, it starts off as a bill. So we have various different types of bill that can go through Parliament. Again, I'd like to get a question on this, but it's worth just having a feel for how these things work. So you've got three different types of bill. There are public bills, which can be divided into government bills and private members' bills. There are private bills, and there are hybrid bills. And I'll explain what each of these is in my next few slides. So if we've got a public bill, remember they can be government or private members' bills. If we take a public bill, that's basically a law, an act that's going to affect all of the general public in England, Wales, Scotland and Northern Ireland. So it would be also true to say that the Scottish, Welsh and Northern Ireland parliaments do have powers to make laws on certain things. And that power is devolved to those bodies to do so. So in certain things, Scotland has the power to make laws that just affect Scotland, Northern Ireland just Northern Ireland, and Wales just Wales. But ultimately, if a law is for the whole of the UK, it's all members of the UK that it affects. So for instance, some examples of laws that are slightly different within, say, Scotland and England would be university tuition fees, because if you're in Scotland, you don't pay them, whereas if you're in England, you do. Whilst we were going through COVID, Scotland and Wales and Northern Ireland had slightly different rules about mask wearing, how many injections you had, when you were allowed to go out, those sort of things. So different laws apply differently, but there will be other laws such as, I know, minimum wage, which would apply across the whole of the UK. So it's a public bill if it affects all members of the public. And public bills basically are divided into government and private members' bills. And ultimately, this is just a description of who brings the bill to Parliament at the start. So if it's a government bill, it's basically bought by the government at the time, and what they're doing is honouring manifesto promises. So when there's an election, the government sets out a manifesto. It's a big list of all the things they're going to do if they come to power. So I mentioned earlier on Brexit, Boris Johnson came to power on the mandate to get Brexit done, and so one of the first acts of Parliament he'll have pushed through will be the Brexit bill, which took us out of the EU. So it's in response, so these government bills will be in response to specific matters or concerns, so Brexit would be one of those, or to comply with international treaties, or to follow recommendations by law reform bodies. And I'll talk about these in a bit. So I've got a link there for you. Now, if you're watching this on YouTube, you'll have to either copy the link, but here's a clip of basically where I'm going from. I've gone to the website of the Law Commission, who are a body that look at our current legislation and try and spot where we could improve. So I've taken a tiny little clip out of their guidance on hate crime. They've done a recent survey on hate crime law, the Law Commission, and they've looked at the fact that this is one of the many recommendations they made, but you can look at the whole document by following the link there. But they've said, look, at the moment we've got four separate laws that all deal with hate crime, and that's not good enough, because what's happening is there's been confusion as to which law applies to which situation. So what we need is to get all these four laws and move them into one new law, and the government then will look at that recommendation by the Law Commission and will then put that in as a public bill. So examples of these sort of public bills that you could think, I've already mentioned Brexit, but COVID legislation would be an example of a response to a specific matter or concern, or sanctions against Russia due to Ukraine. That would be international treaties and those sort of things. So that gives you a feel for what a government public bill is. So it's one that's introduced by the government, honouring manifesto promises, responding to stuff that's going on in the world today, or recommendations for laws that need to be changed. And a private member's bill, again, it's still a public bill, but a private member's bill just means that it's brought by an individual member of Parliament. Now, in reality, not much time is allocated to private members' bills, because ultimately the government will be dealing with their key priorities, so Brexit, COVID, those sort of things, Ukraine. There's not going to be a lot of time for backbench MPs to bring stuff in. However, you know, there are bills, they tend to be these bills that raise awareness of issues or lead to future legislation. So the example I've put down here for those of you watching on YouTube, go to this link, but here's a clip. You know, this is a bill that has just gone through, a private member's bill, just gone through 2022, and that was brought in by this lady here, Rosie Cooper, who is a Labour MP, but also sponsored by Lord Holmes of Richmond, who is a Conservative Lord, so one from the House of Commons, one from the House of Lords, and it's the British Sign Language Act. And basically what that law does is it's to recognise that British Sign Language is a language of England, Wales and Scotland, which meant if it becomes an official language, that then requires the Secretary of State to report on its promotion and its facilitation, and to require government departments to give guidance on how it will be promoted and used. So there's a private member's bill that I dug up. You can look at them at your own leisure by following that link. And what that shows you is that they can be introduced by people in the House of Commons and in the House of Lords, so both houses can introduce them. The best example I've got is actually this one. It goes back to 2010, but the Sunbeds Regulation Act of 2010, that was a private member's bill that was put forward by the Labour MP Julie Morgan, and prior to that bill becoming law, becoming an act in 2010, anyone of any age could go to a commercial tanning salon and get a tan. So you could have a 4-year-old, a 5-year-old, a 6-year-old. There was no law that put a minimum age on sunbeds. And Julie Morgan thought, well, this is absolutely ridiculous. We need to change the law. We need to bring it up to 18. And she got agreement across all the parties, Labour, Lib Dem, etc. And the law went through. So that's what we mean by a private member's bill. Moving on then to private bills, okay, these, unlike public bills, just affect specific organisations, individuals or areas. And they come through, they're petitioned by the individual organisation, so it'll be the organisation that it affects that will try and get the bill through, not members of Parliament. They are very rare. I did a bit of research. There are only 2 have been brought before Parliament since 2019, so that's 2 in 3 years. And the most recent one has been the Highgate Cemetery Act. So when I talk about it, it affects a specific area. This law just refers to Highgate Cemetery and nothing else. The link there for you on YouTube is there, but here's a quick snapshot of what it says. The Highgate Cemetery Act, it came into law March 2022, and it's a bill to confer powers upon the Friends of Highgate Cemetery Trust to operate, maintain and improve Highgate Cemetery, and to get rid of the rights of burial and disturb human remains in Highgate Cemetery for the purposes of increasing space for interments and the improvement of Highgate Cemetery and for connected purposes. So in other words, I take that to mean the cemetery's getting a bit full up, they need a bit more space, so they need to have the ability to double stack a few bodies and move some stuff around, which this law allows them to do, but only for Highgate Cemetery and nowhere else. So that's why it's a private bill. And that then leads us on to our third type of bill, which is a hybrid bill. And these, again, are also very rare. They're a cross between a public and a private bill. They're always introduced by a government minister. And they're rare because they're generally used to secure powers to construct and operate major infrastructure projects of national importance. And the best one I can use is, we've talked about high-speed rail links have been in the news recently, HS2, and currently going through Parliament at the moment, so it's not been approved yet, is the high-speed rail Crewe to Manchester bill. So there's the link, but here's a little clip of it, and you can see it's been brought in by, well, prior to him resigning, Grant Shapps, the Transport Secretary, and basically it's a bill to make provision for a railway between a junction with phase 2A of HS2 south of Crewe in Cheshire and Manchester Piccadilly Station. So it'll be about things like compulsory purchasing land, going through various places, but it's a big infrastructure project, and that's what hybrid bills are for. So hopefully that's clarified the sort of bills that go through Parliament, and you've got a bit of understanding of how Parliament works. So let's go through this process of a government bill. Now, this you need to know, guys. So I've set it out in a very, very brief manner in this slide, but then I'm going to take you to a more detailed slide afterwards in a diagrammatical form, which hopefully will make it easy for you. There are often questions such as outline the process used by government to make a law, and also all you need to do is know this process, but you've got to remember it. So in general, in Parliament, we start with a green paper, and a green paper is basically a consultation where we consult with various interested parties prior to drafting the bill, prior to putting something down on paper. It then moves to a white paper where you're firming up those recommendations from the consultation stage. Now, sometimes a bill starts with a white paper, but usually it goes green and white. It just depends on how complex the bill is. The government then decides to bring the bill to Parliament. So we go green paper, white paper, all sorted out, right, we're going to bring the bill to Parliament. And then the bills are considered by various committees and joint committees as they go through Parliament before being signed off. So here's what you need to know. So in general, we start off with a green paper. We move to a white paper. Notice you can start with a white paper. And then we draft the bill. Now the bill can either go to the House of Commons or it can go to the House of Lords. It doesn't matter which, but it starts in one of these two. If it starts in the Commons, it will have a first reading, a second reading, a committee stage, and then a third reading. And it will then move to the opposite house. where the same process will happen again. First reading, second reading, committee, third reading. So once it's gone through green, white, first house, first reading, second reading, committee, third reading, move to the next house, first reading, second reading, committee, third reading. It then moves to royal assent for the Queen to pass it off. So it can start off with the Lords and go that way and then that way, or it can start off with the Commons and go that way and then straight to royal assent. So that is the process. So basically, green, white, which either of the houses, first reading, second reading, committee, third reading, other house, same process again, royal assent. That is how a law goes through Parliament. So if you get the question, that's what you need to know. So take a snapshot of that diagram, remember it. Don't worry too much about these bits here, that's not a problem. Just those key bits that I've highlighted for you will get you the marks in any question that comes up on this. So, just before we move on, just know the right terms here. A bill is the name of the proposal as it moves through Parliament. So it's a bill as it goes through Parliament, and it becomes an act when it's been approved by Parliament and given royal assent. So basically, an act is the most common way of bringing or making a law. That's how it works. Okay? So just remember that. So a bill it's a bill as it moves through Parliament. It becomes an act once Parliament have agreed and the Queen signed it off. So an act, effectively another word for law. So once the monarch signed the bill, it officially becomes a law. And I'm just going to point you towards this website here. So those on YouTube, there's the link. You click on this if you're on my PowerPoint. And basically, this will take you to the government website, and you can look at every single bill that is going through. You can filter, and then you can have a look at various different bills that are going through, and it will show you. So here we've got the Animal Welfare Bill, brought by George Eustace, who's the Conservative MP for Camborne and Redruth, Cornish MP. Current version of the bill, well, it's 11th of May, and we can see here that it started off in the Commons, and it's had its first reading, second reading, committee stage, hasn't had its third reading yet, and nothing hasn't gone through the bill in the House of Lords, and it hasn't gone to its final stages for royal assent. And you can do that for every single bill that's going through, find the processes, find what it is, and you can filter. It's a great little website. So I'd recommend that to you just to get a feel for how these things work. So that then leads us on to the distinctions between civil law and criminal law, just so we're clear. We're doing criminology, so we're looking at criminal law, but be aware civil law does exist. So civil law is concerned with the rights and duties of citizens and in how they deal with other citizens. So it's dealing with stuff such as lending and borrowing money, entering into contracts, disputes with neighbours, getting married, getting divorced, inheritances, wills, that sort of thing. So that's civil law. But we are concerned with criminal law. Criminal law is offences against society. So it's dealing with matters such as crimes against the person, murder, assault, rape, property crimes such as theft, burglary, fraud, vandalism, etc. So when we look at criminal law, this brings in the role of the judge. And again, there is always a question on judicial interpretation. So when I use the word judicial, I'm talking about judges. Judges, remember, work in the High Court, in the Crown Court. So judges are independent from the police and the government and can't be told what to do or have their decisions changed by ministers. So once that bill has gone through Parliament, it's become an act because it's got royal assent, so it's now a law of the country. It is open to the judges to interpret that law. Ministers no longer have any says. They've done all their checks. So the ministers, the peers in the House of Lords, they've done all their checks. If someone's then unhappy with how judges have interpreted that law, they have to appeal to a higher court. So the laws are created by Parliament, but it's the job of the judge to make sure that people are punished if they break those laws. So, what is the role of a judge? Well, first of all, let's see how they're appointed. In England and Wales, they're chosen by what's called the Judicial Appointments Commission, the JAC. That's an independent organisation. And those people who are chosen to be judges are usually either experienced barristers or solicitors, so they've had lots of experience of working in courts, and the precise level of that experience does vary from judge to judge, but usually they're highly qualified and very experienced people. Now, what I've done here, because quite often you'll get questions such as outline the role of a judge in a High Court trial, I've highlighted the role in bold and in yellow so you can make a note of what the role of a judge is. So judges use their knowledge and experience of the law to, first thing, make sure that a trial is conducted in a fair and legal way. So that's one of their key roles, to oversee the trial, make sure it's conducted in a fair and legal way. And the roles played by judges are different depending on each type of legal case. But in a Crown Court, where the most serious criminal offences are heard by a judge and a jury, in those cases, the judge is making decisions about law and managing the trial. So it's got to make legal decisions because they are the legal expert, but also manage the trial. And the key thing to remember is, and it's quite a common mistake made by students, and God knows why they make it, because it's blindingly obvious the judges don't do that, but actually it's the jury that considers the evidence, and it's the jury that decides whether the person is guilty or not guilty in a Crown Court. It is not the judge. And quite often I see students write, the judge decides in a Crown Court whether someone's guilty or not guilty. That is not the case. It's always a jury in a Crown Court. The judge does not make the decision on guilt. However, once the jury has found the defendant or defendants guilty, it's the judge that issues the sentence, and they have to issue an appropriate sentence. So that's another thing that they do. And then throughout the trial, remember the judge is responsible for making sure the trial is fair. The judge has got to make sure the jury is aware of its legal role, what it should and shouldn't do. It's got to advise them on legal issues and ensuring that that court case stays within the law. So those bits that I've highlighted there for you are the judicial role, the key roles of a High Court judge in a Crown Court case. Okay? And judges have to interpret the law. Now, this is all about fairness. So judges apply what's called common law. And common law is law that's grown out of decisions by judges in court cases over decades and centuries. Because for the law to work, it's got to be fair for all, so it's got to be consistent. So decisions that are made by judges in higher courts are recorded, and then judges in lower courts must use those decisions to help them make their own rulings in court cases. Because that means that court cases aren't just a random thing, but the punishments for the same sort of crime are similar and fair wherever they happen. So that means if I'm caught speeding at 120 miles per hour on the motorway in Devon, and caught speeding 120 miles per hour on the motorway in Scotland, or the Lake District, or London, my sentence, no matter which court I end up at, will be similar, because the law should apply evenly across the whole country. And so once a judge has established a sentence for a particular type of crime, then that sentence must be consistent across all courts. And the role of the lawyers and barristers is to point out those consistencies. So if it happened in this case, then it should happen in this case, so on and so forth. And this then leads us on to judicial precedent. Now, again, this is absolutely key and you must know it. Now, quite often in exams, we'll have what is the judge's role in making laws. If you get the government's role, that's easy. That's your green paper, white paper, first, second committee stage, etc. But if it's the judge's role, then you've got to know judicial precedent, and then a few slides later, statutory interpretation. So judicial lawmaking is when judges set a precedent in a court when a case comes before them, and that judgment then becomes law. And because that judgment's been made, it then follows in all similar cases. This is what I was referring to earlier on. So an example of this, and this is one I've just lifted straight from the textbook, was in the case of, in 1932, there was a case of Donoghue versus Stevenson, where I can't remember, it was Stevenson had manufactured some ginger beer, which was bought by Donoghue, and when Donoghue opened up the bottle of ginger beer, he found a decomposing snail in his ginger beer. So he took Stevenson, the company Stevenson, to court, and the judge ruled that yes, Stevenson had been negligent, and it was quite right that a customer should not expect to find a decomposing snail in their bottle of ginger beer. So they were found guilty of negligence and fined whatever. I don't know what the actual sentence was. We then skip, so that precedent has been set. The judge has made a ruling in that type of case. It may, snails found in ginger beer probably don't happen very often. We then move 6 years on to the case of Daniels v. White. Now, Daniels bought a bottle of lemonade from White, and when he opened the lemonade, there was some metal in it. Now, the judge at the time, and quite sure the barrister at the time, referred back to the case 6 years earlier, where the judge had decided that if a snail had got into a bottle, that was negligent, and therefore, with Daniels versus White, a metal getting into a bottle of lemonade, I know it's not a snail, but it's still the same sort of thing, a foreign object in a bottle of lemonade, which the manufacturer hasn't looked out for. Therefore, because the judge ruled it was negligent in Donoghue versus Stevenson, to have consistency, the judge had to rule that it was negligent in the case of Daniels and White. So consistency, and probably the sentence, was similar, because that means the law applies to all and is fair for all. So that is what we mean by judicial precedent. When the judge decided that that was negligent, he therefore set the precedent, which means that all similar cases that follow become the same. So effectively, a law is created. So that is what we mean by judicial precedent. Moving on to our next, should also just make it really clear that once that precedent has been set, very hard to have a judicial precedent overruled. You've got to go to the absolute highest court in the country. Very rarely are they overruled. We then move on to statutory interpretation. This is slightly different. Statute is just another word for a law or a rule. So this is where judges in superior courts, such as the Court of Appeal or Supreme Court, are sometimes called to interpret words or phrases within a law. And this sometimes leads to the creation of laws. Remember, those laws have gone through all those stages in government where they've been to God knows how many committees, where people have debated over the wording of the laws. But even then, sometimes mistakes are made or loopholes are created. And this is sort of a way of shutting down a loophole. Now, the case you can use as an example of this, and again, this is another one from the textbook, is the 1868 case of Whiteley versus Chappell. Now, I think it was Whiteley was charged with impersonating, the law said, impersonating a person entitled to vote. So the offence under law was impersonating a person entitled to vote. So what the defendant did, they impersonated someone on the voters list who had died. So they'd rocked up pretending to be a dead person and had voted in a general election. Now, the offence was impersonating a person entitled to vote. The barrister argued that Whiteley was not guilty because he wasn't guilty of this offence because a dead person is not entitled to vote. Therefore, he wasn't impersonating a person entitled to vote. So he wasn't guilty of the offence for which he was charged because a dead person is not entitled to vote. So the wording of the law meant that he got off, basically. And this is where judges will then change the wording so that the loophole is closed. So that's what we mean by statutory interpretation. So looking at the wording of laws and what it actually means and whether someone is guilty or not guilty of a specific offence due to the wording of the law. Hopefully that makes sense. So this then leads us on to the last little bit of how judges sentence. So when judges issue a sentence on a convicted criminal, they've got to work within guidelines set by the government. So they can interpret, but there are specific guidelines they have to follow. And again, this is another fail-safe to make sure that sentences are fair, generally similar for the same crimes, regardless of where they take place. So you can go and look at various things. I've just picked out a little website here, defencebarrister.co.uk. You can click on this, but here's just a little clip of what I've taken. I mean, you may well know there's if you're found guilty of murder, it's a mandatory life sentence, but there are other minimum term sentences. So in this example here, third dwelling house burglary offence, where a defendant aged 18 or over is facing sentence for burglary, where the defendant has 2 or more previous convictions on separate dates for the same offence. So basically, if a person has been done for burglary 2 times previously, if they're found guilty the 3rd time, the minimum sentence must be 3 years. So if someone comes up in front of a judge for burglary, they've been found to have burgled twice before, they're found guilty the 3rd time, the judge has to set a minimum sentence of 3 years, no less. So these are the things I mean by sentence guidelines, and you can go look on that website. There are other examples for you. So hopefully that has clarified how laws are made, the role of a judge, and judicial precedent and statutory interpretation. I look forward to seeing you all in my next video. Take care and goodbye.